give us your name?
I'm Eloquent, Director of Eloquent Daycare. We opened around the year of 1988, and of course we were successfully continuing our business practice until 2007. We work very well with the offices of Children and Family Services. They worked with us. We never had any prior problems with them. And our mission was to take care of the disadvantaged children. Even though we served all the children that came to us, we designed programs to fit each individual need of the children whom we served. We also contracted with Erie County Department of Social Services. Events leading to the conspiracy started in about the year 1999. There was a complaint, we were told, that was filed by one of the monitors who had serviced our center. And upon receiving this complaint, the Office of Children's Family Services Director, Ms. Hoffman, removed the monitor from our facility. We were then supervised temporarily until a replacement was made by Supervisor Patricia Hopper, who was the supervisor of Mary Wallace. This complaint seems to have tarnished our relationship between Eloquent and the Office of Children and Family Services. However, on about February the 7th, 2002, the initial conspiracy between occurred when an accident happened on that day. This involved one of the vans that wasn't used to service the daycare, but a temporary van was used by one of the volunteers who picked up children from an outing. During this time, an accident did occur. And when I was notified along with myself and other staff members, we immediately went to the scene and made sure that every child was seen over at Children's Hospital. We had the children's parents picked up and brought over to the Children's Hospital to make sure that they were aware of what had gone on and any assistance that they might need or the hospital might need from them. I stayed over along with the staff members until every child had been released. Except for one child they kept on, but his condition was continued to be monitored. The following day, on the 8th of February, I was approached, I received a call from Patricia Hopper indicating that she would be out at the close of the business day with a letter. At about 7 o'clock on that date, she did arrive with a letter of revocation. At that point, and as of that particular time, we were shut down. I took the case to Supreme Court 2 weeks after that letter and revocation was filed. We were told by a Supreme Court justice that this was illegal and that they were not to shut us down because of an accident. However, Ms. Hopper appeared at the daycare sometime after, approximately a few days afterwards, actually, and said that she wasn't aware that we had been reopened. But from that point onward, we received harassment from her office. She would accompany her monitors out for inspection. Sometimes as many as 5 would come at one time. They would go throughout the building. Oftentimes we didn't know who was there, using various entrances. And we maintained with them that only the primary interest, which was on Bailey Avenue, was to be used, and that way we would know who was in the building. This practice continued, however, which led eventually to a hearing and a stipulation with new charges filed. At one time, I even overheard Ms. Hopper tell her monitors that they were to look and find something. They weren't to congregate in front where she was, but they were to look and find something. This continued for some time until finally we went to, we requested a hearing through their system. We were given that hearing, which lasted about a year. And this, of course, we hired an attorney to represent us in this matter. Their inspectors were all called in to testify about their role with the Eloquence Daycare. This stipulation, again, was brought into play. And we wondered at the time if this stipulation was going to have a bearing on our relationship with the Office of Children and Family Services. But we were told that it was not, by our attorneys working with their offices, that this would bring about an end to whatever harassment that we were going through. But this did not happen. She used a stipulation agreement against me. Initially it was $10,000, and we did talk with them about it, and they agreed to $1,500. This stipulation charge was finally it was paid, and we thought was over. However, the visits even intensified more. And this went on, as I've said, for approximately a year, and they used the basis of this stipulation to bring about a closure to the program, even though they themselves broke the stipulation, because the minute that agreement had been signed, we did find out that they had gone to the office, gone to the Erie County Department of Social Services.
All right, I'll call you later.
And they told them to suspend all referrals to Eloquence Daycare. So therefore, we were sabotaged, and we were wondering when clients would tell us that they were told not to use Eloquence Daycare anymore, that they had decided not to use us. Of course, this did go against the stipulation that we had signed. So in breaking this agreement, parents remained with us regardless. And they would tell their workers that we know this daycare provider, we know her staff, and we are a family, and we wish to stay. So with this, our capacity remained full, irregardless of the false accusations and the charges that were brought against us additionally. And also, these records and files maintained throughout that, going back to that 2007 date, they maintained that was really the basis. And the stipulations was further used as a final basis in shutting the daycare down. We did, of course, continue to battle with them, going into court with them, and of course, finally, we closed the doors of that center. So, any one of the programs that were in business, the program that was in business at the time of our final day of occupying the daycare, we gave those children over to a friend who had also worked prior at the Eloquence Daycare. This friend worked after school, so she was well familiar with the program. But she feared also from the beginning that these people would, with this association with Eloquence, might bring about a different attitude with them. because she initially had a very good rapport with her license. But in the beginning, she enjoyed those few months. Finally, it was known that she did take children from Eloquence, and they would question parents. Parents came back to me and said, well, why are we being questioned as to whether or not we attended your daycare? What does it have to do with that? And so, of course, her nightmare started. And my grandson as well, he was stigmatized because of his association with me, because he was a Quinn naturally. And they weren't fully aware of Olga Cassiano's relationship, so they went through the parents to find out initially. Parents wasn't able to give them specific information, so they used the Erie County Department of Social Services to follow one and to initiate a process of following the parents and finding out where they were going, how long, and question the parents to see how long they had known her, where they were coming from, and if indeed, if Eloquent myself was still involved in daycare. And of course, they said no. Finally, we believe injustices with the facilities that were mentioned, Eloquence Daycare, and as you will see, Olga Cassiano at A Mother's Touch, and finally, D's Delight, DeMario Stevens Quinn, were all part of a plan to go after an individual, associating ones with within their frame of finally taking them out of business. The legal system has shown that there was no reason for them harassing me. The judge decided that there was no reason to shut the business down, but Ms. Harper made it known in the business community that she was going to shut me down because of my involvement of going to the Supreme Court. And she made it known that they did not want daycare programs to file complaints with the court system against the Office of Children and Family Services. So we do believe that because of this and her initial involvement, and of course others coming on board later, that this was their decision, that once you exercise your judicial right to have an intervention in an injustice treatment, that they will come after you. And this is proven to be the case. Thank you.
So, Ms. Quinn, in this unfortunate situation that happened, I'm sure you had your appropriate insurance for through your business and everything, correct?
Yes, I did.
How did your insurance company handle the situation?
Well, the insurance was, I had over the required amount that was stated prior to going into business. So I had insurance that covered the facility as was required.
Okay, good. Now, you had mentioned that you went to the Supreme Court and spoke to a judge in this matter, right?
Yes.
So what was the outcome of that situation with them? What did they say?
Well, the judge, of course, made a decision regarding the matter, and he said they could not shut me down on the basis of an accident. And he said that the insurance companies would work that out. And of course, having the correct insured amount, they did.
So I'm assuming you reopened then?
Yes, we did.
And what happened after that?
Well, that's when the Office of Children and Family Services did come out, and they resumed their inspections on a more frequent basis.
So it's a little, you've been in business for quite a few years, so you would know the difference. Now you feel like you've been targeted now. They're more so to come to you for